This is part 4 of our presentation on the common law marriage myth, which is about inheritance and pensions. When you're married or in a civil partnership, the law, that is, the Succession Act 1965, entitles your surviving spouse or civil partner the legal right to acquire a share of your estate when you die. But this is not the case for cohabiting couples. If it is your wish and intention that your property goes to your partner, this must be expressed legally. Regardless of the number of years during which you have lived together as an unmarried couple, the law does not recognize unmarried partners as kin. According to the law, even if you're currently cohabiting, the next of kin who are most likely to benefit from your estate in the absence of a will are your spouse if you're still legally married, your children, your parents, or your siblings. There is a myth that common law husband and wife has some legal standing. However, when it comes to inheritance, the surviving partner has no right under the existing intestacy rules. What if you have not been included in the will? If a deceased will or the law relating to intestacy does not make a reasonable financial provision for a cohabitant, the latter can make a claim against the deceased cohabitant's estate under the Inheritance Act 1975. However, there should be proof to show that the deceased was making a substantial contribution in money or money's worth towards the reasonable needs of that person. If they were both working and simply living together, they might not be eligible under the Inheritance Act 1975. Cohabiting partners would be entitled to bring a claim under the Inheritance Act provided that they meet the criteria. Preliminary issues such as jurisdiction, proof of death, domicile of the deceased, and the time limit to bring a claim would be considered to state whether a claim may be possible. To be able to make a claim under the Inheritance Act 1975, it must be proved that the partners have been cohabiting for a period of 2 years immediately prior to death, or that they had a child together. Moreover, there is a 6-month limit from the grant of representation. Thus, the claims under the Inheritance Act must start as early as possible after the death. As we are coming to the end of this presentation, we shall now have a Sky News report on pensions for cohabiting couples, as explained by the former Pensions Minister, Steve Webb.